Okay, folks, let's get started. We're setting out now on a long journey, touring the land of conflicts of interest. As a lawyer, part of the duty of loyalty to the client involves providing conflict-free representation to the client. So our first step in this journey is going to be to learn a new language, to learn a vocabulary, that is the terms that describe the various types of conflicts that we're going to run into along this tour. But let me focus on the word conflict. When we say conflict, we don't mean hostility. We don't mean people shouting at each other. Very often, the most dangerous conflicted lawyer is the silent lawyer. The thing we're worried about here is the lawyer who remains quiet because he or she feels torn loyalties between two different clients in one setting. So with that bit of vocabulary, off we go. The first and most straightforward form of conflict of interest would be concurrent conflicts between two different clients. And by concurrent, we mean happening at the same time. One lawyer representing two different clients at the same time. The easiest way to see that happening is in single litigation. So if Fred represents Lynn in some kind of tort suit and she is suing the tortfeasor, helpfully named here tortfeasor, then she would be perplexed, maybe even feel betrayed if tortfeasor said, "What a great idea that you hired Fred. I think I want to hire Fred too. Fred can represent me and Fred can represent you." Doesn't happen, can't happen under our conflicts rules. So that one's pretty obvious. Concurrent conflicts also come up in less obvious settings. So let's say Lynn has a bunch of lawsuits going. She's suing tortfeasor, and Fred represents her in her suit against tortfeasor. But Lynn is also involved in litigation at the same time against infringer, somebody who infringed on her patent or her other intellectual property. In that setting, can Fred represent the infringer? And the quick answer here would be no, Fred can't do that. Even though they're completely different lawsuits, they may be not terribly related in subject matter. Lynn has hired Fred for her litigation on the tort side, and so he cannot represent an adverse client at the same time, even if it's a completely different subject matter. So Fred here, if the question is, can he represent the infringer? The answer is no, you cannot. You're conflicted out. Our main source of guidance when it comes to concurrent conflicts of interest is Model Rule 1.7. All the states have essentially the same rule in place. And under this rule, you're asking, first of all, whether the current client and a proposed second client would be directly adverse to one another. Or second, even if they're not directly adverse, as in a lawsuit, would representing the second client present some kind of significant risk that your representation of the original client would be materially limited. That's under 1.7a, that's the general standard. There are some exceptions, some escape routes built into 1.7b. Most prominently, the client can waive a conflict of interest, at least if the lawyer reasonably believes that he or she can still provide effective assistance to both clients. And as long as it's not in the same litigation, you can never waive that kind of conflict, like Lynn versus tortfeasor. She can't waive that. But in other settings, as long as it's not the same litigation, then there could be a waiver. I want you to try to think of a setting where parties very frequently might see a conflict of interest but be willing to waive the conflict of interest. A second type of conflict is called a personal conflict. It's related to the concurrent conflicts because the conflict is between the client's interests right now and the attorney's interests right now. So there's that time element in common with the concurrent conflicts, but it's the lawyer's interest rather than a second client's interests that conflict with the first client's interests. We've seen hints of this earlier in the semester. There are various forms of payments that a lawyer might take from a client that raised these personal conflicts issues. Rule 1.8 lists several different specific examples of this, and among them are referral fees that we've already seen, limits on malpractice actions. Also, prominently, sexual relationships with the client are included in Rule 1.8. Now, another type of conflict is called successive conflicts, and here we introduce a dimension of time. So now we're interested in what happens when Fred originally represents Lynn. Let's say that it's a sales situation. She's selling something to a buyer, Joe. And once that is over, it's completely over, the representation is done. Later on, Lynn is involved in, let's say, a domestic relations matter of some sort, and perhaps there's some kind of custody dispute about children during a dissolution of the marriage between her and the father of the children. And so during that setting, can Fred now represent Hunter, now that the relationship back from that earlier litigation or that earlier sales transaction is over with? And here the answer's a little bit fuzzier. We sometimes allow these apparent conflicts between an old client and a new client. So the rules are somewhat different, but still there are some situations where the later client, the answer has to be no, Fred cannot represent the Hunter, the father here, because that's in conflict with his ongoing obligations to former client Lynn. Model Rule 1.9 contains the relevant language here. We're basically asking whether the new client brings in some kind of representation that is a substantially related matter to the old representation that is now over for the original client. And the key concern here is that as an attorney, even after I end the relationship with that earlier client, I have an ongoing obligation of confidentiality. So the question is, am I going to be tempted to violate that old confidentiality obligation by representing the new client in a matter that might also involve the old client along the way? We'll get into the details later, but those are the basic questions. Now, this whole structure gets more complicated by the fact that lawyers practice with each other in firms. And therefore, the conflicts that apply to one lawyer who's got his or her clients are imputed to all the other lawyers in the same firm. The presumption here is that partners are walking around the halls and sharing information and bouncing ideas off of each other. And so for purposes of the duties to the client, you treat the entire firm as if it were one lawyer. And so one lawyer's conflicts get imputed to every other lawyer in the firm. This is true for the concurrent conflicts. It's also true for the successive conflicts. You can imagine this makes it somewhat complicated, difficult when a lawyer leaves a firm and goes to another firm. Which of those old imputed conflicts go with the lawyer to the new firm? So we'll be dealing with that question of movement and imputed conflicts. And notice also that in a few settings we allow the attorney to be screened off, to be kept apart from the rest of the lawyers in the firm. But we still treat that as an exceptional remedy rather than the normal one, because our normal image is of a few partners walking around sharing client information and sharing expertise. So with that vocabulary survey in place, we're ready to jump in, but one more note about remedies. Who's going to be enforcing the conflicts rules? In a lot of settings, we depend on bar enforcement authorities as the primary prosecutors and investigators and so forth. But in this setting, while the bar enforcement authorities are interested, and they will act if they run across a conflict of interest, most of the enforcement happens in the litigation context with opponents of the attorney saying, aha, you have a conflict of interest, we want to knock you out of this case. And so it's opponents in litigation that are the primary enforcers asking for rulings from the judge in the litigation. So we have multiple sources of enforcement here, and therefore it's a highly litigated, very complex area of law. And with that cheerful note, away we go.